Hello, folks. Welcome back to SQE1 window. And we are starting our series on legal system of England and Wales. And in that, we have chapter 1 that is dedicated to sources of law and legal system. So we need to understand that what it is, that how UK is governed. So when we say UK, we are really talking about three distinct legal families like living under one rather complicated roof like that we got it. So that's England and Wales, Scotland, and Northern Ireland. So all of them, they are members of this, you can say, complicated but peaceful family. So each has its own courts and procedures. Think of them as three siblings who share the same surname but refuse to borrow each other's clothes. They live independent. At the top of this family tree sits the Supreme Court of United Kingdom, our legal grandparent, if you will. Like at that point, if you accept it, it hears appeals from all three jurisdictions and ensures a degree of harmony, or at least stops too many family argument about what the law means. So at that point, you need to understand the famous case law of R.V. Miller at some point when courts decided different in Scotland and England courts had different point of view. It went to Supreme Court and our own wise Lady Hale pronounced the decision at that point to create harmony in decision making. So another thing that we need to talk about is common law and judicial precedents. So, common law, the great British export that we have done around the world, this is law that judges make through decisions in actual cases. The system runs on stare decisis, it's a Latin word that means stand by what has been decided earlier. In other words, once a high court decides something, lower courts must follow it. If a case has difficult facts, it might be distinguishable, and that is where clever lawyers earn their keep. They make things different, they make results different. Occasionally, a case arises where there is no precedent at all, a matter of first impression, and a judge gets to make new law. I don't think judges, they don't make law, but rather they expand it, develop it. It is rather like bringing, like, it is rather like having a new interpretation or being told to write a new rule book, but only if you are sitting high enough up the judicial ladder. So it's not like county court that creates or develops new rules. It is like Supreme Court and High Courts. They do it. They got authority to do it. So another thing that is very important, and people have love and hate relationship with equity and fairness. So we meet equity, the gentle cousin of common law, you can say. Equity steps in when the law is too strict or downright unfair. It works in personam, meaning it deals with people and their conscience, not with property itself, like at that point. It its remedies are like injunctions and specific performance, and they are granted at the judge's discretion. Like, those are not as a matter of right, it is discretion of judge. And do not forget the golden maxim: he who comes to equity must come with clean hands. So if you have behaved badly, you do not expect much sympathy in courts. Equity ensures that justice is only done in a way that it serves someone who has already followed the law and morality. So that's very British indeed it is. So at that point, we need to understand a new concept, another one, that is Acts of Parliament. So once we talk about Acts of Parliament, the heavyweight champion of UK law, Parliament is sovereign, supreme, and beyond its authority, there is no authority. It can legislate on anything from taxation to tea breaks. If it so wishes, they can just create a law like at 11 you need to have a tea break. You will have to have it. All acts have equal legal status, though a few, like the Human Rights Act 1998, are considered constitutional celebrities. They have special status at some point, but they are equal to other acts at that point because all of them were created by Parliament. To make life easier, minister can also make statutory instrument, we call it SIs. These are bit of delegated legislation allowing quick updates without dragging everyone back to Parliament. It is rather like giving the minister the key to the car, but telling them to stay on the main road. That's it. Don't go beyond. So, another thing that we need to understand, very British, that is devolved legislation and international treaties. Devolution brought new players into legislative field, including the Senate in Wales. They make laws on devolved areas like education and housing. Under the Government of Wales Act 2006, Westminster technically remains in charge, but usually keeps a polite distance unless things go spectacularly wrong. At that point, they intervene. International treaties are another source of law. They are negotiated by the government under the royal prerogative and bind the UK internationally. Once ratified and written into domestic law, they can have a real bite. Until then, they are promises waiting for a signature, a bit like agreeing to do the washing up later at some point. So we also got EU laws. Still, we got some of them. We retained chunk of them, but the procedure has gone different. So that is a topic once caused many sleepless nights, but still it is there. We need to study it. After Brexit, we have what is called retained EU law. It still influences UK laws, but it is no longer taking priority over our own new legislations passed after 31st December 2020. Keep in mind this date. So then we have constitutional conventions, the written rules that keep our constitution running smoothly. They are not enforceable, but everyone behaves as if they are. A bit like queuing at a bus stop, even if it is not written law, but people behave and they just go in queues. Finally, when the law is silent, judges often turn to the great constitutional commentators like Dicey, Freeman, or maybe me as well at some point. That's a joke only. Whose work are as close as we get to an official rule book while actually having one. So another thing that we need to understand about British source of law in British system is custom and civil and criminal law and adversarial system. These are different concepts. So before we finish, we try to talk about customs are ancient local practices recognized as law. If they have existed since time immemorial, or at least before anyone could remember otherwise. Civil law deals with private dispute and uses the balance of probabilities, meaning if it is 51% certainty, the court will go in that way. Criminal law, on the other hand, deals with offences against the state and requires proof beyond reasonable doubt, particularly certain. So our system is adversarial. Two sides argue, and the judge acts as neutral referee. Think of it as legal tennis, but with wigs, gowns, and slightly less running. You don't run in the courts. It's not a football field. So some SQE tips. And finally, we have reached at our favorite slide. So you need to understand that always spot what the question is really asking. Is it about hierarchy of courts, source of law, binding authority, common law, equity, statutes, statutory instruments and all? So at that point, you need to understand what is the concept and then choose the right answer. Be careful with the retained EU law. It still matters for pre-2021 legislations. If you are unsure, use logic and eliminate the wrong options. So remember, in SQE1, accuracy beat cleverness. So the only cleverness is don't be clever there. So thank you very much for joining us in Legal System of England and Wales. We have 6 different sessions on it. So join us for the second session, and that will focus courts and judiciary in United Kingdom. Ta-da!